Hi, Anita. Mark Westcott here. Hello,
Hello,
everybody,
Mark.
and hello again to Anita. Today, our session on estate and succession mastery, and what we call the coach in your pocket. And today, Anita, you're the coach. This is
I
all
am
about
indeed.
technical. This is all the technical stuff today. So I know you've been looking forward to this, but basically, what I thought we'd talk about today, we've talked in general terms about a lot of the human elements and so on before, talking from your heart in regard to estate planning, not always just looking at the legal documents and so on. But today, I thought we'd actually touch on the legal documents. And for a lot of people, Juanita, and you'd know this, they figure that they've got a will in their drawer from 20 years ago, and they figure that's all they need.
Gathering dust.
And it's been gathering dust and becoming more irrelevant by the day. But it's, estate succession planning, and we'll just talk about the estate planning today, but certainly it's a whole lot more than just having a will in your top drawer, isn't it? There's a whole lot
Absolutely.
of other documents and
yeah,
so on.
and yeah, that's right.
Sorry,
I think you would have heard of the saying, more than just a will. So a lot of people just think a will is it. A will is better than no will, but there's a lot more to it.
Look, absolutely. So look, let's just start on. We've got about 7 topics here to talk about, the 7 different documents which people may or may not need, and certainly the most important one is the will. So let's touch off on that. Start off on that one, and effectively, there's wills and there's wills, aren't there?
Absolutely. There's all types of wills, basic, more complex ones with testamentary trusts in them, and different types of trusts. But I think, Mark, as you said, the point here is that you get the right advice and you're informed, and then you make the right decision as to what you need. So, as I said, a will is better than no will. And I think that's because you are able to make some choices that you would otherwise have if you didn't have a will. So the basic purpose of your will is to document how you wish to leave your assets, your estate, after you die, and who to. But there's a lot more things that a will can do, which people probably don't think of when it first comes to mind. So, for example, in a will, you can nominate who you would like to administer your estate. So you nominate your executor. If you don't have this in your will, then it could be the result that the person you don't want doing that, or you're not comfortable with doing that, ends up doing that. Further, there could be some further costs which are incurred by your estate after your death. So you get to choose who you want to look after your affairs basically after your death by nominating your executor in your will. Another really important thing that you can do in your will that a lot of people don't think of is that you can nominate your wishes as to guardians of children. So if both biological parents have predeceased, then this does carry some weight, subject to any final decision of the family court, who always decide what's in the best interest of the child. But it's a pretty powerful thing, I think, to, in your will, be able to nominate who you would wish to look after your children if you weren't here, or if both parents weren't here. Of course, then we come down to the nitty-gritty, which is in your will, you can set out what you would like to leave to whom. So there are different ways this can be done. You can just leave the whole lot to someone. And of course, this is after any liabilities are paid, which is the law. You don't get away with that, unfortunately.
You can't skip all the debts when you go.
No, bummer. But, you may choose to leave specific gifts to specific people, particularly for things like family heirlooms or things of sentimental value. You can leave your whole estate to someone, or you can leave proportions. And then, of course, there are different structures that we can put in place to provide additional benefits, such as trusts and capital preservation, which, we won't get into too much detail here today.
Sure. Actually, just before you keep going on there, and not that I'm suggesting anyone tries to avoid paying off their debts, but the truth is there's certain assets actually don't go through your will anyway, do they? So if all your assets were owned in superannuation funds or or family trusts, or if you had life insurance with beneficiaries that you might have your spouse or your children as beneficiaries, all those things don't actually go through your will at all anyway, do they? So
absolutely, that's right. And a misconception, well, probably not a misconception, just something that a lot of clients that come to see us just don't realise. So, for example, jointly held assets such as a joint bank account with your spouse, or a property held as joint tenants, which is as opposed to the term tenants in common, means that when one person passes away, the asset automatically goes to the survivor. It doesn't go through your will, so you don't have a say in that particular instance. As you mentioned, also superannuation, and we'll talk a little bit about binding death benefit nominations shortly, but superannuation is totally separate to your other assets which you can leave in your will. So it's really important to understand how that flows through and what you need to put in place, because especially these days, a lot of people have their wealth in superannuation. So it's a very important document.
Yep. So where there's a will, there's a way.
You had to throw it in, Mark, didn't you?
I just had to do that one. You knew it was coming. I
had to throw it in.
I've been sitting here for 5 minutes wondering when I could just drop that one in.
Well, you've done it.
But I've done it now, so now we can get on and be sensible. But certainly, talk please, if you would, Juanita, about the guy before he committed suicide that typed his some notes into his iPhone, and they found it, and that was constituted as a legal document. I mean, this, and I don't mean to confuse everyone here, but you know, people have written wills on the back of a piece of paper, and you know, as they're dying, and they've had two people sort of witness the scribbles on a piece of paper, and they've been constituted to be legal wills. Now, having said that, there was a lot of you know, had to go through court for that to be declared as a genuine will. So
we don't recommend anyone write their wills on their beer cartons or stubby coolers or iPhones, etc. That is not the advice from today. However, there is a special area in the law which allows for such pieces of documents, such documents, to be held by a judge as an informal will. There's a lot of hurdles to cross before such a document can be held as a will. It means that you have to go to court, or someone has to take it to court, and costs tens of thousands of dollars. So for saving a few bucks and writing a will on a Post-it note or any such thing, you're not really saving any money. That's why it's not recommended, because there's a lot of expense involved in taking something like that to the court to get it, I guess, held as an informal will is what we call it in law land. And it may not just happen too. There's lots of specific legal tests that have to be passed. So possible, not recommended.
Aren't you glad I brought that up? Not.
Oh, I could talk more about that topic. We'll save that for another time. There's some really interesting things that have been held as wills, absolutely, but certainly not the recommended choice.
And at what cost and at what aggravation to family. So
and I might just, sorry, Mark, I might just add there, when you mentioned cost, a very common question we get is, why can't I just do a will kit down at the newsagents? And the answer is you can, but I in my experience have seen that go wrong so many times by the wrong things being written in an attempt to make it clear, and it ends up being a lot more expensive. Things being left out, like superannuation, like we just spoke about. So, you know, I always am of the philosophy, a will is better than no will, but a wrong will or a badly drafted will is a disaster.
Yeah, look, as you know, I often talk about in webinars, on all the podcasts I do, and any videos I throw up in the world. I always talk about the fact that about 95 to 97% of people who make wills aren't specialists, and I always talk about, you know, if you've got an estate over $5 million, you need to go to one of the 3% of lawyers that really know what they're talking about. And you know, if there's not a lot of money and there's not a lot of beneficiaries, you know, you want to go to the newsagent and make life complicated for everyone after you're gone, that's your option. But I mean, what we're talking about here in regard to to estates and succession planning and so on, I mean, you need to take professional advice. You need to get it done properly, because one of the biggest growth areas, and it disappoints me, this part is contesting wills, isn't it?
Absolutely, absolutely. We're seeing more and more and more of it in the courts in Australia. It'll continue to grow. It's a growth area of the law. Unfortunately, as you say, a common question which I thought of as you were just talking that we often get is, what happens when there is no will? And the answer to that is that there is a formula set by the law which decides who gets what out of your estate. So for most people, that's a little bit unsavoury, that you have no discretion or no involvement at all as to who gets your estate. It's purely prescribed and it follows a formula. So often not a great result.
So ballpark, if mum and dad both didn't make it home last night, and if dad didn't make it home last night, and mum and 3 kids are left, and let's say there's $10 million and there's no will, ballpark that's distributed, does it depend the formula, or is
that's right. The formula depends on if there's a spouse and if there's children and how many children, and then if there isn't, then it cascades down to other relatives. But the issue can be there that in the example that you just gave, where one spouse passes away and there's children, then it does get split up between the children also, and it might leave the surviving spouse with a bit of a shortfall, or issues with the family home, because the family home has to technically be split up between the children. So that formula can be very problematic in some particular fact scenarios.
Yeah, I'm always a good one at looking at the worst case scenarios, but I mean, if you've got children, if there are children and they go through divorce and all those sorts of things, it means there's no protection of assets for failed marriages, bankruptcy, and all those sorts of things. And as you say, it could leave the spouse without a house to live in.
Absolutely, it's possible. Yeah.
If there's not a good relationship between mum and the kids can just sell up and take their money. And so, yes, this is one of these things. I always say what you do is a bit akin to brain surgery. If you've got a brain tumour, you don't go to a GP, and you certainly don't go to the newsagent to find out how to fix your brain tumour. You don't go to Google. You actually go to a specialist and so on. So wills are just such a fundamental and important thing. I mean, for goodness sake, I was talking to someone yesterday, a farmer, and in their 50s, 3 kids. They don't even have a will. And it's there, and there's 90-odd% of people don't have an up-to-date or appropriate will. So it's just how it is. It's not good, but our purpose is to make it better.
It's not top of the list of fun things to do, is it? It's not a exciting topic that people rush off to do, but it's a must.
Yes, not dinner party conversation, as we say.
Not. Well, not at most people's places. Maybe at ours.
It might be at yours. Okay, so let's talk about enduring powers of attorney and the confusion between sometimes powers of attorney, enduring powers of attorney, and so on.
Oh, sure. Yeah. So an enduring power of attorney is a document that allows you to nominate who you would like to make decisions on your behalf when you lose capacity. That is mental capacity. And it can also be drafted such that while you still have capacity, you can give your authority to someone to make decisions on your behalf. For example, if you're on a cruise over in Europe. But the important part of this is enduring, which means that when you lose capacity, the document kicks in and continues until your death. And that's where it's different from just a general power of attorney, which doesn't continue. So this very powerful document. So you can nominate who you would like to make decisions on your behalf when you lose capacity for both financial matters and personal and health matters. So they can be the same person, they can be different people if you think different people are suited to the particular decision. And you can nominate a single person, you could nominate multiple people and dictate how you would like them to make decisions. So jointly, majority, for example, if you have a few children that you want to be involved in those decisions. So look, these days it's terribly important, particularly with people living longer lives, and having that document in place, because if the unfortunate should happen and you need someone to be there making decisions for you, that document's in place.
Yep.
Also, as I said, for financial matters, it's a very useful document, even though you may still have capacity. So you haven't lost your marbles yet, shall we say. But if you are, as I said, on a holiday overseas, you can nominate someone to fill out documents at the bank for you, is an example. So it's a very good logistically to have that in place, also very useful in our daily lives.
Sure. If you're going through a property deal or something like that, and you're in Antarctica and can't be contacted, then a power of attorney will allow someone to sign those documents.
Absolutely. Oh, absolutely. Yeah.
Not that any of us will be going on cruises for a while.
No, we won't, or planes. But when we do, it'll be good to have that in place. And I should add there, and like we said for wills, an enduring power of attorney is a form. It's a template. However, again, getting that specialist advice is really important, because these days we draft particular terms in enduring powers of attorney. It's not just a tick and flick, tick the boxes and move on. We draft particular terms in there which allows your attorney to deal with things such as your superannuation, land employment, make sure that we allow for certain situations which may be relevant, such as conflicts of interest and gifting. So there is a danger in just ticking and flicking the form and putting it in the top drawer that it hasn't really achieved what you might want it to achieve when and if you do lose capacity.
Sure, and you touched on one of the things earlier too, and that is you may have certain people in your family that are more astute and more controlled in regard to financial matters. And you might have other people in the family who are a bit more compassionate. If you're lying on your hospital bed, they may be a little more compassionate about keeping the power on or turning it off. So, they can be different people.
Yeah, that's right. And I guess that leads us a little bit into the next document that
we should talk about advanced health directives.
Yeah, absolutely. So, you touched on the people that need to be making health decisions for you at that crucial time. As we said, your attorney can make those decisions on your behalf, but this document, again, a separate document. I'll often say to clients that this is a really useful document if you have very strong particular beliefs on matters such as resuscitation, life-prolonging medical treatment, etc. Or it's also very useful if you want to take that pressure away from your attorney. So, if it's there and it's documented, it's what you wanted. Emotionally, it can be a lot easier for your attorney when they're sitting there or standing there being asked by a doctor what to do to refer to that, than have to grapple with that themselves, even though they may know your wishes. And also, if there's a potential, if you have a couple of attorneys, for example, that you're worried there might be some dispute or disagreement between different family members when that decision comes. For example, if you had a couple of children, they might not agree on those health decisions. This can help eliminate potential disputes and acrimony down the track. So it's a pretty confronting document in some ways. It asks very specific questions, as I said, about those sort of medical matters. You are actually required to go to a doctor and get them to sign off the document in front of you after having explained the terms and being satisfied that you have an understanding of what you're signing to and what you're ticking and the terminology. And then again, similar to an enduring power of attorney, it also needs to be witnessed by a qualified person, being a solicitor or a JP.
Yeah, and I guess the big advantage of these health directives is, if you've got children who are sitting there going, how can we let mum die, or how can we let dad die, you're naturally going to be compelled to go for resuscitation. And yet the person at that stage in life might, and which is why you have this, is what they're saying in their mind is, for goodness sake, just let me go. Don't resuscitate. And it takes away the guilt and not the grief, but certainly the guilt in making those decisions.
Yeah,
Because
and this allows you to document. Absolutely. Yeah. Yep.
Yeah.
Absolutely. Yep.
Okay, so let's, and that's a very important document. So let's move on now to letter of wishes for guardians and executors.
Yeah.
Let's talk
So
about
this is
why this is important.
Yeah, this is something that you may choose to accompany your will. So it is, as the name suggests, a letter that you can express your wishes to the person or persons that you've named as the executor of your will. That's the person who carries out their duties to administer your estate, or the guardians of your children. And they could be the same person, quite frankly.
Sure.
But an example of the sort of things you might put in there would be to the guardians of your children. You might put down what your wishes are, especially if you've got minor children, as far as where you'd like them schooled, or what type of schooling or education that you wish them to have. You might like them to be able to enjoy travel, or be able to enjoy sports, or that sort of thing. It basically, you can write down your philosophies and wishes for the upbringing of your children, so your guardians know and have some guidance for when they're making those decisions, and when they're, looking after those children after your death. And
sure.
Similarly, with the wishes to the executors, you might want to put in certain wishes and directions as to businesses or entities that may assist with them with controlling those entities after your death.
Okay, no, that's good. Now you mentioned before about superannuation, so let's talk about nominations, and it's not just the binding death nominations, but nominations full stop in superannuation funds. And maybe here you can touch on too, ownership in life insurance policies and how important it is for that to be reviewed.
Yeah, now we could do a whole session on binding death benefit nominations, couldn't we? So
we could
indeed. So a death benefit nomination allows you to nominate who you would like to receive your superannuation benefits on your death.
Yep.
Some superannuation trust funds allow them to be binding, some don't. It depends whether they're self-managed or whether they're retail funds, and different aspects there. So that's probably the first little tip, is often, especially with the retail funds, these nominations, if you have them, expire every 3 years, so they need to be renewed. Your super beneficiary, though, another little tip, can only be certain types of people. So you can only nominate your super beneficiary to be a spouse, a child, a dependent, or your estate. So you can't nominate your neighbour, you can't nominate your cousin, you can't nominate your brother.
No,
you can't nominate your mate. No. So it's quite specific. And if you do nominate a person that's ineligible, then the nomination is invalid. So lots of nuances with these death benefit nominations. But these days, particularly with a lot of wealth in super, and also specific rules around taxable and non-taxable components.
Sure.
These nominations are very important. Well, we've said that for every document so far, have we? But
they all are. That's
why
we're doing this.
Yeah, but I think with this one, a lot of people don't know they exist, don't know what they are, don't know what it means, didn't realise that your super didn't go in your will. So it's important to know if you have one in place. And that you've got the correct beneficiary nominated, and you get the right advice around the taxable and non-taxable parts of your superannuation.
Most certainly. And I mean, the most obvious thing here, Anita, is if you distribute your superannuation funds equally between your spouse and three adult children, well, there's going to be tax payable by the 3 adult children, and the spouse could get it all tax-free. So you're better off giving the super, in some cases, to the spouse, and other assets to other beneficiaries, to make sure you minimise your tax. So these are, once again, why it's very important to look at these documents, look at the estate as a whole, and to make sure you've got these documents. They're not delinquent. I used to call these things, people have a pile full of delinquent documents because they're all out of date or not appropriate anymore. And there was a message came up a minute ago. One of our viewers has just put in there, he needs a review. You've obviously said
Well,
something which has prompted that along the way.
yeah, and I suppose speaking of reviews, a lot of people ask how often should I review these documents, and the answer to that, I would normally say either every few years or on a significant event such as someone's death, someone's birth, marriage. Oh, we didn't mention that, Mark, did we? So, you know, marriage and
No,
divorce
I'm glad you brought that up.
yeah. Well, maybe I'll finish what I was going to say first. Selling of businesses, buying of properties, that sort of thing. You should always review your will and your estate plan. Now, doesn't mean you need to change anything. It may be that you've structured it, you know, it's been structured perfectly and you don't need to change anything. But on any of those events, and every few years at least, we would recommend that you at least take a look and check that it's still all in order and it suits you for your purposes.
And certainly in regard to divorce, it's always good to check the beneficiaries in your superannuation fund, and certainly in regard to your life insurance. You know, a very close friend of mine still had his ex-wife as beneficiary of his $2 million policy for about 5 years after their divorce. So
very common.
Very good one to check.
Very common after separation that ex-spouses are still beneficiaries of life insurance. Of course, it depends on the circumstances of the relationship with super. They might not be eligible, but you'd still prefer to have them updated, obviously, than run the gauntlet. Marriage and divorce also have an effect on your will. So unless the will's made in contemplation of marriage and you get married,
you don't
your
have a will.
will is revoked, you don't have a will. And we go right back to the start where we started quite a little while ago, so that's totally ineffective. And likewise, divorce triggers certain things to do with your will. So they are hugely important if you're in those circumstances to take a look at those documents.
Yeah, and I guess that's, you know, we have different roles. My role is to keep in touch with the client every year and make sure that if things have changed, that I bring them back to you to make sure those things are brought back up to date. So we've just got a few minutes now. So deeds of variation to FDTs.
Only a few minutes. God, we could talk about this all day, couldn't we? We love it.
We could.
Yeah. Now we're getting to the sort of bespoke documents that not everyone needs, but some certainly can make very good use of. So if you have family discretionary trusts, you can't leave the assets that are owned by the trust in your will because the trust owns them. But what you can dictate or control is who will control the trust afterwards. So as part of your estate planning, we would always look at your trust deed, have a look at who controls it now, who controls it after your death, and whether there's any variation required, or more particularly, whether a succession needs to be documented so you know that who's going to be in control of that trust after your death.
We'll just cover the one more topic just very briefly, then I want to come back to the due diligence, which we talked about last week. So estate obligation deeds, just briefly.
Another bespoke document which is not required by everyone, but may suit some families. Particularly, we see it a lot in rural families, don't we, Mark? So where the deed may help even up gifts and obligations as part of the estate planning down through a generation.
Yeah, so if one child ends up with a farm and they're trying to work out how they haven't got enough money to sort of create fairness between the other kids, then that's where these things come in. So I want to just come back a couple minutes to go and what you were talking about there with deeds of variation. I mean, all these issues, deeds of variation that may be required because of depending on how the control of trusts are going to pass, the binding death nominations, insurance beneficiaries, health directives, and so on. I mean, this is all the stuff that, you know, last week when we talked about your due diligence report, your proprietary report that you do for clients. I mean, this is the kind of stuff that you take care of, isn't it? And look at for the clients to make sure all these things are up to date, and where they're not up to date, they're not appropriate, or there's options that clients can have. It's your role to bring that to their attention, correct?
Absolutely. So, you know, as part of your estate planning, we're doing a bit of digging, and, you know, we're asking what your circumstances are and what your entities are, and reading the documents that are relevant to that, to give you our recommendations as to which of those documents we think would be useful to you. And then it's up to the individual whether they put that in place or not. At least they're informed and they know the risk of having not having something in place.
Sure. No, absolutely. Well, Juanita, we covered a lot of really interesting stuff there, and I guess the point was we wanted to bring up today is that some people, as I said at the top of this, was some people think, okay, well, we've got a will, it's sitting in the top drawer, that's all we need, and even though it's 15, 20, 10 years old, whatever, they kind of figure that's all they need in their life, and having that gives a sense of comfort, which is very, very misguided. So, as I say, if you've got any level of wealth and you're concerned about how that passes to the next generation and to your spouse, to the next generation, and so on, it's just ever so important, isn't it, to sit down, have a chat, review all these documents, ask questions about whether these documents are relative or not, and to you, and do something about it, to take action to create peace of mind for those left behind.
Absolutely.
So once again, Juanita, look, big news, huge, massive news. We're now
What's that, Mark?
We've become so excited with doing these that we're changing these now to weekly.
Yes,
instead
we
of
are.
fortnightly.
Yes, we are.
We're having our estate and succession mastery sessions weekly. They will be streaming both on YouTube and on Facebook in our Facebook group there. So look forward to being able to provide real value for people on a weekly basis. And the feedback we've had already in regard to these sessions has been very very heartening, and I'm very grateful for those that are watching this and getting some value, and especially for you, Juanita. Thanks for your time, effort, and your wisdom, because you're the smart one in this group, and I just organise it all, and you turn up with the brains.
I say nothing, but no, happy to help, and also, happy to answer any questions that arise out of these sessions for anyone that's watching.
Yeah. If anyone's got any questions, please make comments. You can make comments in the Facebook group or on the YouTube feed, and we'll get back to you. Or at least if we can't get back to you, if we're not sure who you really are, we'll make sure we cover it off in the next session. So thanks everybody, and thanks again, Juanita.
Thanks, Mark. Thanks everybody.
Thank you.
Bye.
Bye.
What were you doing?